Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you each and every Sunday at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. And, of course, and as always has been, always will be, I, Doug Clark, the Clark Law Firm, has not, will not, and we do not represent gas or pipeline companies. I represent royalty owners, oil and gas right owners, and landowner, property owners in Pennsylvania. Have never, ever represented the gas or pipeline company, and I give you my word, I never will. I never, ever will. They could pull up a Brinks truck to my home or my office, and I will gladly ask them to please back it up, because they have enough lawyers on their side fighting for them to make sure that they're getting the best possible deals for the multi-billion-dollar cap companies. We need people dedicated to work for you, the property owner, the oil and gas right owner. And if you listen to the show, hopefully it comes through. I love what I do. As a kid growing up in a very rural area, steelworker father, retired steelworker, has a small farm, still does the farming. I love representing people like my parents, like my cousins, and all the people I grew up around with in Armstrong County, Pennsylvania. I love my job and I love what I do, and I'm going to keep doing it. And I'm going to keep putting out the best possible information to get you thinking, to make sure that every listener, landowner, property owner is thinking about the critical issues, hot issues, important issues facing them at every step of the way. Have been doing the show since 2010. Again, I have been doing this radio show since 2010, and I am not stopping. There is always new issues that are arising, and surprisingly, sometimes these issues are more critical and scary than what we've seen in the past, which probably surprises people. We still routinely see, and I continue to talk about it, and I will continue to talk about it, we still continue to see leases presented to landowners, which will allow for deductions from the royalty payments. And they are being represented to landowners as saying, oh no, there'll be no deductions. And many times it's a game of semantics, but for you, the landowner, you better understand that game before you sign, because what you think may be royalty without deduction, what you're told is royalty without deduction, in most cases, in my experience, that is not what you're getting. And if you're signing a lease without understanding that, and you think you have royalty without deductions, what is the basis of that thought? Well, in virtually all cases, it's going to be what the landman who works for the company, not you, the landowner, tells you. Now, this is an interesting thing. It just happened to me this week. Spoke with the landman. Landman says about the company, well, I'll go and I'll ask and I'll see if we can get this approved. And then during the part of the conversation, he goes, well, I don't work for, and he said this company's name. Well, you know what? Let me ask you this question. When I'm a lawyer and I have a client, and Mr. Smith is my client, I, Doug Clark, get paid by the Clark Law Firm. That's who pays me. The client pays the Clark Law Firm for representation. So I have a client, let's say Mr. Smith, who I am representing Mr. Smith. Mr. Smith does not pay Doug Clark into my bank account. Mr. Smith makes any legal fee payments to the Clark Law Firm, and I have a salary situation that I make from the Clark Law Firm. So I work for the Clark Law Firm. I do. But Mr. Smith is my client. So landman, let me tell you this. Maybe your check comes from XYZ Land Service Company, XYZ Land Brokerage Company, but your client, the client of your employer, is the gas company. So I view what I do not as I work for the Clark Law Firm. I view what I do as I work for that individual or those individuals who are my client. And I'll tell you what, that landman, it's easy to say, oh, yeah, well, I don't work for them. No, they're your client. They're your client. You go in, you go get your hair cut. Does the person who's cutting your hair, they work for the business that they're employed by? But you're their client. So don't tell me you're not working for the person who you're cutting their hair. Don't tell me I'm not working for the person who's hired me through the Clark Law Firm, who's hired the Clark Law Firm. No. Your client is the company. Your client is not the landowner. No, your client is the gas or pipeline company. So I don't want to hear it. I don't want to hear it. We cannot, I can't say this enough, you as a landowner, you cannot rely on the person or people representing the gas or pipeline company to tell you, to give you, and to explain to you the information that you need to know. This, guys, this is elementary. We can't rely on the other side to tell us what we think we need to know. Think about it. Think about the class actions with 15,000 plus people who feel that they have been cheated because things were misrepresented to them. That's what the cases are about. They believe there was misrepresentations. There was cheating going on. But now we're going to, let's say those are true. Let's just say it's true. Again, these cases are out there. Are we going to rely on the same people where there's litigation scattered throughout Pennsylvania to tell us the truth and the information that we need to know to help us make our decisions? We have to be smarter than that. And I know that we are. We cannot, you cannot, in my opinion, the whole show is opinions, but I'll tell you, there's very few things that I can think that I have a stronger opinion on work-related that landowners, property owners, oil and gas right owners cannot, you cannot be relying on the company representative to tell you and to give you the information that you need to know to make the right decision for yourself. And I say this, if you don't care about yourself, if you have kids, care about them and care about your grandkids, because we need to maximize your situation. And I assure you, the companies are looking to maximize their situation. That's okay. We need to understand the playing field, the ground rules, and we need to have the best result and best outcome we can possibly get in that environment, in that arena. So let's stop simply signing documents. Let's remember about the landman is not working for you. Ask to see his card, her card. Ask to see it. Look when it says at the bottom, because this is always funny too. Well, that's not my client. I don't work for them. I don't work for them. Look at the bottom. You'll see representing such and such a company. John Smith, representing, authorized agent of. Look, these arrangements, they didn't just pop up over time. There's a process, an evolutionary process of how, on a company side, do we get people to sign the most advantageous agreements to us as a company and the worst agreements we can get them to sign for them as the landowner. Well, we don't want to have our own company people go out there, so let's insulate ourselves. We'll hire a land service company, and then later on, if the people complain, in other words, but if people complain, we'll say, hey, well, you know, that landman shouldn't have told you that. That wasn't a company employee. Well, no, they were contracted by you. You paid them. You were their client. But it's the old Plausible deniability. Well, hey, they shouldn't have told you that. Well, you signed the agreement. And the guy or girl who you dealt with and you signed the agreement, try to find them. Typically, they're long gone. They're in Ohio, somewhere else, West Virginia, working on another project. Gone. And now you're dealing with company people saying, well, hey, here's what the contract says. We have to be smarter. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me each and every week, and I hope you do, at this time on this station for All Things Marcellus. You can call the office about potential representation or for representation, 570-307-0702. You can keep listening, like I said, each and every week, and go to the websites, pagasleaseattorney.com, pipelineattorney.com. Again, let me say those websites again because too many people are not going there. They are a resource, just like the radio show is. And whether we ever talk or not, I'm encouraging you, please use the resources. We want everybody to do better. Remember, the show is never specific legal advice. The websites are not specific legal advice. However, they are resources. They get you thinking. What should you be worried about? What should you be looking for? The subject today is going to be amendments and ratifications. Amendments and ratifications. Sometimes you'll hear A&R, which I always hate when people use these acronyms when they're words that people don't deal with all the time because it confuses you and it makes them seem more powerful or they have an edge over you because they're using acronyms which you don't understand or you're not familiar with. It's not that you're not able to understand, you're just not familiar with them. So again, amendments and ratifications, sometimes referred to as A&Rs. But I'm going to talk about that here in a minute. But for now, I really want to hammer this point home. I do it all the time, but I just want to hammer it home even more. We have to stop signing documents. We have to stop signing bad agreements. We don't have to just stop signing documents. We need to stop signing them before we speak to somebody working for you. Before you have those documents reviewed and you have a consultation to discuss what is in the documents, what are you giving up and what are you getting? We have to stop that. People are still doing this probably every day, and we have to stop it. The information is out there. There are people out there who can help you, who truly have the motivation to help you, to make sure that you actually understand the document in front of you, to make sure that you understand how that document will be interpreted and how it will apply to you for the next 50, 100 years or even longer. These are not contracts like my dad handshaking, selling bales of hay out of the field. These aren't those types of contracts. You are dealing with multi-billion-dollar companies with a potential, depending upon your acreage, to generate potentially millions of dollars from your property. Do you think they're coming out there and saying, hey, how can we do this to give the landowner the best deal? No. They are doing it to say, okay, how do we maximize our situation? How do we do as best we can? I've done a show before, fiduciary relationships to shareholders. These guys are bound, when I say guys, girls, I don't mean gender specific, to maximize profits. Now, maximizing profits can at times lead to certain benefits, and it does to people, but that's their goal. There's a reason they're not giving everyone 20% no deductions. No, there's a reason. So now, more than ever, we see how companies are manipulating, in my opinion, leases, pipeline agreements, other contracts in order to maximize the benefit to them. Creative contract interpretation. To me, That's the number one problem that people face as we go forward whenever you sign these leases. And we see how companies will interpret, especially royalty provisions, because that's where the big money is. We see how they will interpret these contracts in order to pay you literally the least amount of royalty that they can possibly pay you. To see how they can set the gas price for the sale as low as they possibly can. Then, how they can maximize deductions of every kind possible. Commission fees, amortization, pipeline depreciation expenses. We have to do everything we can to stop that. And I'll bet you anything. Well, yeah, I'll bet you anything. That no landman, in my opinion, well, okay, listen, this is a hypothetical bet. They're not saying to you, hey, look, let me tell you what. Here's the deal. This royalty calculation provision, man, you can potentially get whacked here because this royalty calculation provision allows the company to sell gas to an affiliated company they own at the well site at a discounted rate and then set your royalty value at that rate. This agreement allows us to charge you sales commissions. It allows us to charge you pipeline depreciation and amortization expenses. No one's ever called me and said, oh yeah, the landman said, hey, watch out for this. This is a really bad provision. No, in the contrast, what I get often is, I do these reviews and consultations all the time, and what I get is, oh, well, I got royalty without deduction. I got royalty without deduction. I got royalty without deduction. I say politely, why do you say that? Why do you think that? Well, the landman said, shocker. I get sent to me today, all the time, still in leases. Well, we have this cost-free royalty provision that the landowners really like. Well, yeah, which landowners? Ones that certainly didn't have an attorney who knows what they're doing, because the cost-free language, quote, cost-free, is used to give people wellhead price and affiliated sales in tens of thousands of cases. But yet, the person tells you it's a cost-free royalty. The person working, whose client is the company, they tell you it's cost-free royalty, and you believe it. We have to stop that. We have to stop it. And I'm going to tell you, it's just true. One way to make sure that you understand, and I don't want this just to be a giant commercial. I want everyone to understand these things. But reviews, consultations for any contract, any documents, even if you have a question about it, if you think I can help you, give us a call. I want to help everybody I possibly can. I mean that. If you're going to sign a lease, pipeline agreement, and I'm going to talk about amendment and ratifications today, the big subject, give us a call. Learn about reviews and consultations. I do them all myself. No other associate attorney. I do them all. You can come to the office. I'd love to see you. We sit down in the conference room. We talk. We go over everything. We can do it by telephone, regardless of your location. You hear me say I have clients various places across the country, in other countries. We do them by telephone. We can do group calls. We'll do whatever's necessary. And if it won't work, I'll let you know immediately. Hey, there's an issue here maybe with distance. But I'm going to tell you, that's maybe happened in the last many years, like literally a couple times. So give us a call and learn about reviews and consultations of any contract. Learn about gas lease negotiations, pipeline reviews. We are here to help you. I'm here to help you. And if you don't call me, and I want you to, call someone else who's going to work for you and knows what they're doing and is going to explain these things to you. These aren't hay bales out of the field contracts. These are big time contracts. And you need to make sure that the person who's working for you is working big time on your side, not the other side. So give us a call, 570-307-0702. 570-307-0702. I want to hear from you, see what we can do, see if we can help you. Give us a call. And keep listening to All Things Marcellus each and every week at this time on this station. When I get back, I'm going to talk about amendment and ratifications, which are a big, big deal now. I'm going to talk about those. I'll be right back after this super important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station for All Things Marcellus. And as always, I have not, and I will not represent gas or pipeline companies. You can give us a call, 570-307-0702. Again, regardless of your location, reach out and see if we can help you. Another thing that's important, I do all of this myself. There's no associate attorneys that you're going to talk to. You'll talk to me. And I will personally represent you. And my commitment to all clients is to do the best job I possibly can. And I also encourage people, if you're considering representation, you want to learn more, or you just want knowledge, again, go to the websites, pagasleaseattorney.com, pipelineattorney.com. If you have a pipeline agreement and you're not going to pipelineattorney.com to get information, I don't know why. Whether we ever talk, just get information. It's general information, not specific legal advice, just like the show isn't. But get information. Information, education is key. Get that information, and you cannot rely on the gas or pipeline company to give you the information and education you need in negotiating these contracts and putting the words into the contract. Money is a big thing, but gosh, it's not the only thing. You need to maximize the money, you need to minimize the intrusion, and you need to set yourself up for future opportunities to either say no or to negotiate for additional benefits. You need to make sure you're doing the best in each and every single transaction. And remember, again, I'm talking about, and I talk a lot about reviews and consultations because they just work so well. I've never had a person say, oh my heavens, I can't believe I just wasted my time. Routinely, wow, you gave us a lot to think about. Wow, I'm so glad that we did this. Okay, hey, what do we do next? The reviews and consultations usually take an hour or two. Including the review and the in-office or phone call. And I do most of them by telephone, but we do them in office, and everybody is welcome to come to the office, for the review and consultation. So really encourage you, give us a call, 570-307-0702. Learn about that service. And of course, I represent people for gas lease negotiations, pipeline agreement negotiations. I think at this point, we're up over 70 different pipeline companies that I've worked on agreements, consultations, reviews across Pennsylvania. 70. So again, I know, and this isn't to be a wise guy, I know something about pipeline agreements. I know about markets. I know about what you can obtain. And we can do a review and consultation. So you can just do an hour or two and get information and then decide if you want to go forward. Again, I can do a negotiation if you want. I do estate planning. I'm doing more estate planning work with clients as they're starting to get more royalties and gas money. Unitization issues, royalty issues, deduction issues, litigation issues, property issues with the gas or pipeline companies. And of course, if you are shut in and you're in, let's say, Tioga County, but you could be other places, but we all know that's where a lot of, in my opinion, bad things are occurring. If you're shut in for 8 years or more and you have at least 100 acres, I would like to hear from you, and I'll do a review and consultation and see if we think you have a claim, and then discuss how you may want to go forward. But again, it has to be, and I'm sorry, but at least 8 years of shut-in and at least 100 acres. And I'd like to hear from you, and we can talk about what the potential options are. Because like I've said, this issue is driving me crazy, and we have to stop it. For the people, we have to stop it. And I may be, naive, but I don't think so. I believe it's wrong, and I think we can ultimately make it stop. And that's what we're trying to do. And I am committed to that issue. I promise you, I am committed to that issue. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So let's turn to it. Amendments and ratifications. I want to say it again. Amendments and ratifications. Sometimes they're amendments, modifications, ratifications. The word ratification, that is a potentially dangerous or even deadly word to you as the landowner. Ratification, ratify. Why would I be getting a document such as an amendment, modification, or ratification from a gas or pipeline company? That is the first question that everyone should ask. Also, when they are given that document, the first thing they should do is make sure that their hand does not pick up a pen, because we do not want to simply sign amendments and ratifications, nor do we want to simply sign any agreement without understanding it, having a consultation, and understand what you're being presented and why you're being presented it. So, why would you be given an amendment and ratification? Again, it could be modification, so just pay attention. Ratification is the key, but this should apply for any document. You should be saying, okay, put the pen down, let's figure this out. But amendments and ratifications, why am I getting it? Let's pretend it's for a gas lease. Well, there could be many different reasons. Many different reasons. I'm going to tell you this, though. I don't care what the company tells you. You are not given an amendment and ratification because it's simply in your best interest. They don't just say, we want to amend and change and modify your existing lease to benefit you. Now, in certain cases, you can obtain benefits, and if you're smart, you're going to maximize any benefit you may be able to obtain, which you should be doing, but think about it. How many times has a company came up and knocked on someone's door and said, you know what, you had 12.5% royalty, and the standard across the state pretty much everywhere is at 15% or higher at this point, so we feel bad. So we're going to, we'd like to amend your lease and pay you 15% royalty instead of 12.5%. And that's all we want to do. We just want to give you some more royalty because, we just feel that it's, we feel bad for you. You signed for real low. You got 12.5%. You're getting full deductions. So we want to amend your lease and give you 15% because we're nice guys. It's not happening, guys. It's not happening. Now, what can happen is there may be a flashy object, a flashy term in an amendment and ratification. Maybe they do, maybe offer you an increase in royalty percentage. Well, if that's the case, why? What else am I giving up? You have to know the answers to these questions before you sign. So, you could be asked to sign an amendment and ratification and be told it's for a certain reason, and this is my experience, but hidden in that document, in the legalese, is the real underlying reason why the company really wants that amendment and ratification. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week for All Things Marcellus at this time on this station. So, you may be given a ratification because the underlying oil and gas lease has probably terminated. Let me say that again. You may be given an amendment and ratification because your actual gas lease that you believe still exists, it may have actually legally terminated. And the company says, we have here an old lease that, let's pretend we use this example. It's been shut in for 10 years, 15 years, and maybe we didn't even make payments. So we want to go and develop this area. So let's figure out, how do we get the landowner to sign? Well, the landowner's probably frustrated because it's been a long time and they're not getting any royalties and they've seen other people sign. So they said, let's send a landman out and we'll give them an amendment and ratification. And we'll tell them, hey, look, we want to start producing. We want to get you royalties. We want you to be rich. We want to give you money. So we want you to sign this amendment and ratification before we do anything. Now, there could be some sort of ratification saying we're going to have a larger unit. There could be all kinds of different reasons or paragraphs, but generally it's going to be a small document. But the real issue, there may be some like shiny object terms that you're looking at, but the real issue is the ratification language, because the company knows that if they just went out to drill or just went out to develop your property and you didn't acknowledge that your old lease was valid, that you could sue them, that maybe you don't have a lease. And then maybe they would have to pay you a new bonus. And that bonus may be a couple $1,000s or more an acre. Maybe they have to give you a higher royalty, 15, 16, 17, 18%. As opposed to the 12.5% you have now. So imagine, let's pretend you have 100 acres, and the market in your area is $2,000 an acre. Well, a new lease would give you $200,000. And let's say the new leases in your area, the royalty rate is 16%. So you could go and immediately get $200,000 in a bonus for a new lease, and you could jump your royalty from 12.5%, let's make it 15%. So you can jump your royalty. Or you could sign an amendment and ratification and stay at 12.5% with full deductions and never get any new bonus. And you can do that by not asking questions. Well, you can ask questions, but you need to get somebody who understands these issues who can help you to make sure that you're asking the right questions. You're not making a bad decision. You're listening to All Things Marcellus with attorney Doug Clark. Join me each and every week at this time on this station. So, we need to make sure that we're asking, why are we given this? What do we need to know about? And let me give you, you know what, I'm going to talk about specific language. Let me set the stage. You're given an amendment and ratification of the oil and gas lease. So, I'm going to go from an example of one here. I'm going to start with, and this one, the company says, hey, we want to change the unitization and pooling clause. And they give the person a document entitled Amendment and Ratification of Oil and Gas Lease. So the only big change is, in this case, they want to delete the existing pooling clause and insert new language. You have to understand all of that, what that means. But maybe the real key in this document is paragraph 3. And I'm going to go through some examples of ratification language. And I'm telling you, if you have a pen, pencil, paper, write down amendment and ratification and always know that you're not signing that unless you're getting assistance. That's my opinion. That's my general advice, not specific advice. I will be back after this break. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm, where you can join me each and every week at this time on this station. Give the office a call, learn about reviews and consultations. If you have an amendment and ratification, put the pen down. Same with other things. Give us a call. See if we can help you. See if you like what you hear. Go to the websites. Check out the testimonials on pagasleaseattorney.com and pipelineattorney.com. I'm just so proud of those, and I mean that. Check it out. Give us a call, and if we're not right for you, that's okay. But find out and do it before you sign. 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Make sure, join me each and every week at this time on this station for All Things Marcellus. If you can't, then you can go Monday morning. This show will be up on the websites, pagasleaseattorney.com, pipelineattorney.com. As I've said, I've been doing the show since 2010. There are many hours of radio shows on the websites. So go check it out. Find a show that may interest you if you're interested in pipelines. We're talking today about amendments and ratifications, royalty issues, whatever it is. There's a show there for you. Buying and selling gas rights, whatever it is, go check out the websites, pagasleaseattorney.com, pipelineattorney.com, and call the office and learn about different services, including, but not limited to, contract review and consultation services. It's a great way to start, and it usually takes an hour or two, and you don't have to go any further, but it's a great way to start to get you the information that you need. So we're talking about amendments and ratifications. Now, again, that word ratification is the biggest buzzword that should be buzzing in your head. That means that you are ratifying your existing document. I'm going to get more into detail of that in a moment. So, you may be presented with an amendment and ratification because the company, you may have a restriction in your lease about the size of a unit. That's a common one. We don't see those so much anymore. But again, these amendments and ratifications are not being presented to you because it's going to simply benefit you. No, the company needs it. That's why it's presented to you. Again, the company needs it. That's why it's presented to you. You now need to understand what, if any, benefit this document is going to give to you. How is it going to apply over the lifetime of the document? And what benefit, if any, are you going to get? And again, what detriment? So we need to make sure that you're identifying that. Now, let me give you a killer amendment and ratification example. And please, if you are shut in, please turn the radio up. So, this happens. People across western Pennsylvania have been shut in, literally, at times for decades. Not just 8 years or 10 years, but 15, 20, 25 years and longer. And many times in western Pennsylvania, because they were shut in and there was no real big money involved in these gas leases in the 80s and 90s, the company just quit paying shut-in payments. And now you can say, hey, my lease is ended. You didn't pay me my shut-in payments for the last 20 years. And what did the company do sometimes? What do? They'll send you 10, 15, 20 years of shut-in payments. And then if you cash that check, they'll say by cashing it, you ratified the gas lease. However, sometimes the companies realize, we've had this lease and shut in when we shouldn't have, or we've had it too long, and we're scared that we don't have a lease, or we didn't make the payments that we should have made, and the last thing we want to do is give these people a new lease. Because if we do, we're not going to be able to pay them today under a new lease 12.5% royalty with every deduction known to man. We'll have to give them a higher percentage at least because the market is higher now. They also know that if they do a new lease, they're going to have to pay a new bonus. Generally, in most places in the north, that bonus starts around $1,500, sometimes higher. They know in the southwestern part of the state that bonus number is going to be even higher, typically in the few thousands of dollars. And the royalty rate could be up to even 18% we see. So why would they ever want to? Again, let's go back to my 100-acre example. You have a 100-acre landowner. Why would you want to pay them a new lease at $2,000 an acre, which means you just gave them $200,000? Then let's say that you raise the royalty rate from 12.5% to 15% is what you get under a new lease. Well, listen to this. The difference between 12.5% and 15%. Well, let's say 15 minus 12.5 equals 2.5%. Simple math. Even I can do that. But that increase of 2.5% royalty results in a 20% increase over what you would be paid in your existing lease. And here's what I mean. Let's say at 12.5%, you would get $100,000 of royalties, let's say in a year or two, whatever time frame. But if you would get $100,000 at 12.5%. But if your lease was 15%, you would actually get 20% more money in royalties. So instead of getting $100,000 of royalties, if you had a 12.5% interest lease, if you bump that up to 15%, you now get $120,000. If it was $10,000 you got in royalty at 12.5%, if you had 15%, you would get $12,000 in royalties. So you need to be maximizing these opportunities. So the company, again, they are smart. They don't want to pay you extra royalty. So they say, okay, let's keep it at 15% because then let's keep it at 12.5% under the old lease because then we don't have to pay them a lump sum of $200,000. Then we don't have to pay them 20% more in royalty. And of course, if the market is 17, 18%, that amount of royalty goes much higher. So of course, they don't want to give you a new lease. So what do? You're listening to All Things Marcellus with me, attorney Doug Clark. What do? Well, they say, how can we make sure that we're not exposed to liability and develop under this old lease so we can not pay the person any bonus and we don't have to increase the royalty percentage by giving them a new lease with a higher royalty percentage? Well, here's the answer. Amendments and ratifications. So let's amend the lease in some fashion, and we can maybe even amend it in a way that doesn't hurt us, and we can say, hey, landowner, this is good for you because we're going to do something nice for you. But really, what we are concerned with and what we really want is the R word, ratification. So let me create for you a potentially real situation. And this we have to be aware of. And you need to, if you remember one thing, amendment and ratifications, pen down, phone up. So you're shut in. And there's people in Western Pennsylvania that have been shut in for decades. And they're presented with a document called amendment and ratification. But I want to sound the alert as loud as I can for Tioga County, because I do believe that you will start seeing more and more amendment and ratifications. Why? Because maybe you have been shut in too long. Maybe the company can't just sit there year after year after year with a vertical well that they don't produce from, that they voluntarily place into regulatory inactive status with DEP and tender you year after year these minimal shut-in payments and never pay royalties to date for you. So what the company then says is, okay, we need to get these people to sign something to verify or ratify the existing lease so we don't need to give them a new one. So they come with amendment and ratification. And if there's a shut-in issue, there's probably something in there about shut-in, but it doesn't have to be. But what they care about, so imagine this. Imagine you're shut in 8-9 years in Tioga County and you have big acreage. Imagine you're in Western Pennsylvania, maybe you're shut in 15-20 years or more. And they come to you and they give you this document and say, hey, we're going to start producing. We want to get your money. We're going to make you rich. We're going to make you rich. We just need you to sign this. And whatever else they're saying. But you know better. You know the words matter. The words on the paper matter. The printed words matter. Not the verbal words. The printed words matter. So we look and we see, oh, wait a second. I've only been paid shut in. I haven't received royalties. And it's been 8, 9, 10 years, whatever the case may be. And I have some concern about this provision, landman. It says here, ratification of remaining lease provisions. And that means, so you're changing one provision, but you're ratifying all other provisions. And here's the wording. In this case, lessor and lessee, meaning you and the company, hereby, number one, ratify and agree that the lease, now this is an older lease, that the lease is valid and in effect. Stop. So you're saying my old lease is valid and in effect. You're saying that and you're signing your name to it. What if it isn't? What if you had legal grounds to terminate it? And you could have got $200,000 in 15 or 18% royalty if you knew that and you terminated it. Number 2, you agree that the lessee is not in violation of any terms or provisions of the lease. Well, that should immediately make you scared. You should be paying attention to that. Again, you are agreeing that the company is not in violation of any terms or provisions of the lease. Oh, and there's some more to this one. Including any royalty or rental payment terms thereof. Shut in is called shut in royalty. They don't say shut in, they say royalty. Smart. They are smart. We need to be smart too. Then number 3, the third thing is you ratify and affirm that all the terms and provisions of the lease, the old lease, to the extent that they are not changed, altered, or amended by this agreement. So let me again explain. They change one term in your lease. Then they say you agree that the old lease is valid, that it's in effect, that they haven't breached it, and they've properly made all payments to you. Think about that. If you are shut in and you're given one of these documents, put the pen down immediately and call me or call somebody. But this is and has the potential to be an enormous deal. 570-307-0702. No one should be signing amendments and ratifications without a consultation and review, either in my office or with somebody who knows what they are doing. Again, my example, you have 100 acres. The market's $2,000. You have the potential of maybe a new lease for $200,000. You have the potential to increase your royalty percent under a new lease by maybe 20 to 40%. And instead you say, oh, okay, well, apparently the landman said this is good for me. Where do I sign? We got to stop it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station. Sorry, I want to get to more substance. We got one segment to go. Give me a call. Reviews, consultations, any representation, 570-307-0702. We got one more segment. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark. Make sure you join me each week at this time on this station and give us a call, see if I can help you. 570-307-0702. We have another short segment here, so let me jump into it. So, again, amendments and ratifications, but all other documents, put the pen down, pick up the phone. Get a review, consultation, great way to start, and then see where you go from there. Amendments and ratifications, this is going to be, and it already is, an enormous issue. If you are shut in for years and you get an amendment and ratification, alarms should be sounding everywhere. You need to understand what the heck is happening because your lease may have been violated. Your lease actually may have terminated, or you may have extremely strong arguments to that. So if you were ever to amend or modify or ratify your lease, you may be able to negotiate for significant benefits. But even if you get a benefit, don't think, oh, well, I got a benefit, therefore that was enough. If the company's offering it, you might be able to do better. So again, say you went from 12.5% to 15%, even though that's a 2.5% royalty increase, that results in 20% more royalty for you over the lifetime of the lease. So that's just one example. But here's the key. When you sign these, you are ratifying your old lease, which may have terminated. Same thing with pipeline agreements. Remember, these are not offered because they're nice guys and they really like you. They're offered because the company wants it. Why don't you go offer them to amend your lease? Let's see how they respond. No, they want some benefits. They're going to explain to you why it's so good for you, but clearly it's going to be good for them or they wouldn't be giving it to you. So the deadly term is this ratification. I read this one. I'm going to read it again. I have a couple others. So when you sign this, you're saying that, in this case, that you agree that you're ratifying and agree that the old lease is valid and in effect. You agree that the company is not in violation of any terms or provisions of the lease. So you're agreeing to that as of today. This goes on to say, including that they're not in violation of any royalty, which is also shut-in royalty, payments or rental payments thereof. Making these ratifications and agreements can be enormous. And I've personally been involved in cases, where amendments and ratifications, to me, is unbelievably clear that the lease is expired. So you better figure that out. And when you talk about these shut-ins, you may have a claim that your lease is expired. You may be able to either negotiate the amendment and ratification or don't sign it because your lease may have expired. But you got to know those things. Or you could just sign it and get no bonus, no higher royalty, or no other benefit and never know if that was even possible. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So you say, well, hey, maybe ratifications aren't that bad. You're just hand picking one. Okay, here's some other ones. Here's two other ones I just this morning copied and printed just for the show. Lessor, you ratify, adopt, and accept and confirm that the above described gas lease, oil and gas lease, as amended, insofar as it covers any interest in the above described lease premises, as being a valid and subsisting oil and gas lease. And you hereby grant and lease onto the company all of the gas and oil that may be produced from your land, described under the same terms and provisions as contained in said lease, meaning your existing lease, as amended as fully to all intents and purposes as those said terms, provisions, and covenants were set forth herein at length. In other words, you're saying, yes, I agree that all my lease is valid, and I'm essentially re-signing my lease at this time. That's my interpretation. Next, you, lessor, ratify and confirm the lease and all of its terms and provisions as amended, and you do hereby grant, lease, and let the lease premises onto the company subject to the terms and provisions of the lease. Your original lease. The one that may have terminated, the one that maybe they couldn't shut you in for 8, 9, 10 years, 15 years, or 20, but you just probably let it all go. You let it all go because you didn't pay attention to this ratification language. And shockingly, nobody representing the company pointed that out to you. What a shock. Nobody told you that you're ratifying and agreeing that your old gas lease is still in effect. Nobody told you that you may have a claim that you were inappropriately shut in for too many years, that your 1999, 2000, 2001 gas lease probably isn't still valid. However, the company presents amendment and ratification, says, hey, we want you to sign it. So again, lessor ratifies and confirms the lease and all of its terms and provisions as amended, and does grant, lease, and let the lease premises onto the company under the same terms and provisions of the existing gas lease and the amendment. And you hereby and acknowledge and agree that the lease is valid and shall remain in force and effect according to the terms thereof. Amendments and ratifications, please put the pen down. And this is the same with all documents. I know I preach a lot about the review and consultation, and I do so because they have proven to be so valuable. I really want to hear from you. I want to do as many reviews and consultations as I possibly can to get this information out there. So give us a call, 570-307-0702. If you don't like what you hear, don't call back. But give us a call. Get somebody working for you who really wants to help you. And remember, stop signing bad agreements. The landman works for the company, not you, the landowner. Let's put down the pen, pick up the phone. Keep listening to All Things Marcellus with me, Attorney Doug Clark, and have a great, great week, everyone. I'll see you next week.